Jamie White, who is the director and founder of Pod Legal, a boutique law firm with offices in Brisbane and Melbourne. I spoke to Jamie and his wife Karen a few weeks back, more so about how their firm is using social media and content marketing to build their brand and to generate new business leads. But Jamie and I had a great conversation prior to that interview around social media and the law, which is an area of specialisation. So I thought I'd get him back in and we can talk a little bit more about copyright and social media and content marketing. Thanks for joining us, Jamie.
Thanks for having me, Trevor.
Jamie, it's because I guess content marketing is growing so quickly, as in people are using content. The whole world now is blogging and doing video and taking photos, etc. There's a lot of grey area in this space. Now, you're an IP and technology lawyer specialising in social media. I'd love to sort of get some definitive answers from you, because I know people ask me this question a lot too, and I haven't got the answer for them. And that is, particularly if you're a blogger and you need a photo to, I guess, illustrate a point or to just add some colour to your blog post, you use a photo that someone's taken without permission, but you link to it and you acknowledge it. There's a school of thought that that's okay to do. Is that okay to do?
Unfortunately not.
Curses.
Attributing a work to the author or creator of that work is not enough. That's just one of the moral rights that the creator and owner of that work has. What we're talking about is something separate, and that's copyright. Okay, and when we're using a photograph that comes from a third party, we need to make sure that we have permission to use it. Okay, because if we reproduce that image or a substantial part of it without consent, then that will amount to copyright infringement.
So, do you think it's always going to be different if the blog or the online magazine is a commercial enterprise, and therefore the creator of the work will say, well, you're making money off me, versus a blogger who is just a one-man show and blogs out of passion? Do you think that makes a difference?
It could do. At law it won't. However, the attitude of the owner of that original work, in which copyright subsists, might have a different view. They might think if there's benefit for them, if it's linking back to them, arguably there's benefit, and that might deter them from instigating any sort of action against you for copyright infringement.
Are we seeing more of that as more content is being produced and people are probably becoming a little bit more savvy? I mean, the early days of the social web, it's fair to say that it was all about the sharing and the Creative Commons and acknowledgement as well.
I think more and more owners of copyright work are becoming more sophisticated in terms of what their rights are with respect to that work, and I think that has motivated some to pursue potential infringers or infringers, in fact. So we're certainly seeing more and more matters come into our firm initiated by owners of copyright where that work has been reproduced without consent.
And is that more in photographs?
Often it's in relation to photographs, so quite often our client will be the photographer who's done a search of their photograph online and found that it's being used by another party, whether it be commercially or not, and that will motivate them to prevent the use of that photo. But often it also leads to the payment of a license fee or royalty, if you like. So, you know, the message there is that if you're using content, photographs or otherwise, that you're not permitted to use, you don't have consent to use, then you run the risk of being chased or found out and having to pay a license fee, and sometimes they're substantial.
And what are you talking about there in terms of what would be substantial? So if you've used a photo and the other party doesn't want you just to take it down, but they want compensation, that can run into the thousands.
Oh, absolutely. It's not unusual to see matters come in where the owner of the photograph would be demanding $5,000 and upward, and in terms of calculating that fee, quite often there is no obvious calculation. It's just a random number that they've pulled for use of a photograph for a period of time, so the risk is real.
Yeah, and the photographers that are claiming copyright, and rightly so, but as the law states that they're entitled to, are they mainly professional photographers, are you finding?
From our experiences, they are, and the reason for that is because it's the professional photographers, the photographers that are looking at making a living out of their photographs that need to protect their economic rights, and that's exactly the purpose of copyright. So, yeah, the short answer is yes. Usually, it's the professional photographers.
So what about if, I mean, the copyright is still the same, that if someone took an Instagram shot and you've used that Instagram shot, acknowledged it back again, but they're totally amateur and they've taken it on their iPhone, the rights are the same, but they're not professional photographers. So are you seeing any cases where people are arcing up like that?
Not so much, and depending on the social media platform that these photos are being posted to, there's various terms and conditions in place. So quite often when you submit a photograph or a piece of work through or post it on a social media platform, you're, by way of terms of service, you're allowing other people to share that content. Yeah. You will maintain ownership in most cases, but you will be providing a license to have that content shared.
And what about other types? So let's look at text, for example. A lot of companies, probably more so companies than individuals, are curating content in their area or their industry or their space. What's the go there if you're curating? Okay, you're saying, well, you're a blogger and you're saying these are 10 stories that have caught my eye this week, and you've put the heading and the first couple of paragraphs and then a link to. So acknowledgement, not passing off at all, and just acknowledging that this is a worthy article that's caught your attention. Where would that person stand, whether it's a business doing it or a solo blogger?
Well, as we raised earlier, there's the moral right, the right to have a work attributed, so that's one thing, but quite separately is the copyright. And the question we need to ask, or the question that the Copyright Act requires us to ask is a piece of original work being substantially reproduced? Okay, and that's where it starts to get a little bit blurred. There's no short answer for that. We're not talking about quantity of how much of an article's being reproduced. We're talking about the quality. So is the headline and the introductory paragraphs going to be deemed as being a significant or key part of that work or not? And depending on the outcome of that is as to whether copyright infringement has occurred or not. There's been cases overseas where it's been held that a headline will attract copyright or be sufficiently original to attract copyright. There's been similar types of cases here in Australia, but it's certainly not a definitive position at this point. So best practice and to minimise risk, I would recommend that you always contact the owner of the original work and ask for consent to share it in the way that you propose to do.
That's probably not likely though with a lot of people, because otherwise they'd never, if you're a blogger and you had 10 articles and it was timely that you got it out that day because it's links of the week, I'd be very surprised if anyone has the bandwidth to do that.
I would agree with that, and you know, highly impractical. However, the Copyright Act is fairly clear in that you need to obtain consent, because if you don't, you will run the risk of copyright infringement occurring. And I must stress that we're not anti-social media and sharing information. We do that ourselves, but we must be very careful that we don't share the information in a way that we're not entitled to do that. So.
And I think the curation one is going to be the really interesting one, because ultimately, if you're linking to a blogger or even a hardcore news outlet, their magazine or their online newspaper, they want the traffic. So it's actually, in a bizarre way, they'd want you to,
Sure.
they'd be wanting you to put your content, because that's what it's all about. So,
and that will be the case the majority of the time. However, we must understand that there are also people out there like the professional photographer we mentioned earlier who make a livelihood from their content, so we must respect that. And to not is to run a very real risk.
And I guess the difference, of course, is that the photo is used for different purposes. The link to a curated article is actually just driving traffic. It's not passing off. I think where the people who are, and we see it quite often, I think it's called scraping. I think the term is where they're taking some sites take the whole blog post and some instances are passing it off as their own. That's at the murky end for sure. That's not acknowledgement or curation. That's pure ripping off.
Blatant copying. So that's certainly where you'll run into risk. And a lot of people think, oh, it won't happen to me, but trust me, eventually you will get found out.
Yeah. And the third one, so we've got text and images, which would take in illustrations. The third one would be video. Now this is the interesting one, because wouldn't it be if you've put a video up to YouTube and you've enabled, because you're allowed to disable, you're enabling the sharing of those videos. Is that, where do you stand with that then? Isn't that encouraging people to share it?
Sure. The fact that you're enabling it and therefore providing a license to other parties to use it will certainly be a defence to anyone that's using that content. So by enabling, you're certainly issuing a license to share.
So the video copyright stuff would be that if you're videotaping a performance, so say there was a busker, and you were videotaping a busker, that's their performance, you're sharing it. So you're the, on one hand, the content owner or the creator, but you're shooting someone else's performance. Is that a murky area? Or?
It certainly is, and I'm not sure that we've got all day to discuss that one, but...
Sorry to drop that one on you. I'm trying to think of a way where video is, you know, there is copyright around video, and it's more the what's being shot versus the creator of that video.
An example might be this video that you're shooting now. You as the person carrying out the video will own copyright in the video itself. So, you know, you as the copyright owner will have the right to issue me a license, for example, to display it on my website, or perhaps issue other people licenses also. So, yeah, they're the basic fundamentals of copyright as they apply to video.
So let's just summarise those. So when we look at photographs, so if you're a blogger, or you're a like a solo blogger, you're a business that creates content on a blog or on your website. When it comes to photos, to err on the side of caution, you take your own photos. If you're using someone else's photo, you ask permission, or you use one of the many royalty-free libraries of photos where you pay fees which are quite small these days compared to a few years ago, to be able to use it, although you'll probably say that you've got to look at the terms and conditions of those royalty-free photos.
Sure. So I guess with all original content, the steps to take are, ask yourself, do you own it? And if the answer is no, the next question is, do I have permission to use it? And as you say, there's different ways that you can get permission. There's also royalty-free photographs, but there are some licensing terms that apply to those photographs. So if someone is allowing you a license to use a particular piece of material or photograph in this case, you want to ask, what are the terms around that? Is it for single use only? Is it for open use? Is it just for online? Is it not for online? So there are restrictions on licenses, and quite often that will reflect the amount that you might pay for them as well.
And so text is, I think, the hard one. I think that's where the real grey is. So my opinion on that is, which is not law, by the way, I might think I'm a law unto myself, but no, not really, is that, you know, if you're blatantly knocking people's stuff off, that's a no-go zone. I think the whole area of content curation, I think until there's a big ruling on it, I'm not so sure where that's going to go. I think you look at the outcome for what the content creators are getting out of it, and they're getting traffic and someone building their brand and their site and promoting their site. So they're all real positive things for the people who are getting their stuff. And again, it's the spirit of acknowledgement and saying this is a good link and I recommend that. So there's that. What about, I guess you can also take that, it's different to be curating content for your blog, but what about then on Google Plus or Facebook, where you can take the heading and the first couple of paras easily and share it with people. Now, Google Plus can be probably more open, and Facebook sometimes can, or it can be locked down to a personal network. Is there a view around that, or is that just going, no one's ever going to bother?
Certainly the copyright laws apply to all mediums, whether it be online or offline. So the same laws that apply in the offline world as far as copyright goes will also apply online. So, you know, the fact that you might be posting third-party content on your Facebook page, it's irrelevant that it is on your Facebook page, the same laws will apply. And it might be timely to bring up too that you might be liable for third-party content as well. So there's been sufficient court cases around this to know that you will be liable as a publisher for third-party content, and you will have a duty to act in relation to any content that may be questionable in any way.
So what you're saying there is if you're you've got a brand page on Facebook, for example, and you've got the comments enabled so people can come in and write, and before you moderate, someone puts on a comment. There's been cases in Australia, hasn't there?
Yeah, there has. A couple of years ago there was a big case on this, and that was to do with false testimonials. It was where someone had left testimonials on a website and a Facebook page. The owner of those pages knew that the testimonials were false but didn't do anything about it, and in that case he was held liable for that third-party content, and it amounted to misleading and deceptive conduct. We've also
that was also health related products, wasn't it, where the rules are a lot more stringent?
Correct. But I think in that case, those additional rules that apply to that industry aside, it was still found that false testimonials...
So false testimonial is one, probably the biggest issue the brands face is comments that are derogatory,
discriminative, harassing. Yeah, and we've seen some activity around that in the last 12 months or so. Notably, one of the very first cases was to do with a Facebook page, VB, the beer Facebook page, and in that case, the Advertising Standards Board deemed that a Facebook page where products are promoted will be deemed to be advertising, and therefore the code, relevant code applied, and in that case Carlton United Brewery, as the owner of the VB brand, was held liable and needed to remove the content very quickly. And further to that, a lot of people were saying, well, how soon do we need to pull down content? And the ACCC, the Australian Consumer Watchdog, stepped in and said that big companies, big businesses will have 24 hours or so, and smaller businesses might have a little bit longer. So the big takeaway from that is there is a large expectation that you monitor your pages, whether you're a big company or small.
Over weekends.
Over weekends, at least. If you're a big company, you need to do it more often.
So, which way forwards then? Where do you see things going? Obviously, as Facebook gets bigger and brands get bigger, you know, more presence on it, people are spending more time adding comments, etc. Is this, you see that as an issue, or not so much an issue, but something to be aware of? I mean, the law is catching up in that regard? Yeah,
sure. We're seeing more guidance from the courts and relevant bodies. But as engagement through social media increases, we're going to see more and more cases. But I think monitoring is the big message. Keep in touch with what's being said about your brand, not just from a legal perspective, but also from a branding perspective and reputation perspective. I see that there's a great demand for knowledge around social media. A lot of brands are looking at understanding the rules to play by, the playbook a little bit better, and then they'll know what to look out for, how to engage themselves, and of course the implementation of social media policies is certainly something we're going to see more and more of.
There's been a lot of instances like overseas, and I might get into the cases because they're quite long and involved, but where the law seems really out of touch, and particularly around the area of injunction. And I know this is going off marketing, but sometimes that will be the case. But in terms of the law generally and social media, do you think it's still behind, or is it catching up, or is there sections of it that the commercial side of law is catching up, whereas the whole bit about injunctions and that type of thing is really well behind?
Yeah, I think in a lot of ways the existing laws are quite sufficient for to address social media. There's certainly some changes that are taking place. In particular, the Copyright Act is undergoing amendment currently. But all in all, I think the existing laws do cater for social media, but I think some future cases would certainly help clarify the position and give people more confidence moving forward in relation to their conduct with social media.
So reducing the grey areas.
And ultimately reducing the grey area, providing further certainty.
Yeah.
Yeah.
All right. Well, thanks very much for your time, Jamie. It's there is still a lot of grey. I know the law is black and white in a lot of cases, but it's the interpretation is the grey.
Sure.
But I think, watch this space in terms of, as you say, as instances come through in terms of cases and settlements or whatever, is to give us a few more guidelines as to where social media is headed in terms of the law.
Absolutely, and we look forward to interpreting those cases and passing on the information with brand owners.
Where can people find you?
podlegal.com.au, Facebook/podlegal, or at podlegal on Twitter.
On Twitter. Got everything lined up.
Certainly have.
Thanks for your time.
Thanks, Trevor.